Hello, and welcome to Law and Democracy, a podcast of the Election Law Program at The Ohio State University Moritz College of Law. I'm Tony Gaughan, and I'm joined by my friends Ned Foley and Steve Huefner. Today, we are discussing two brand new Supreme Court rulings. One is a campaign finance case, and the other is a mail-in ballot case. The first case is titled National Republican Senatorial Committee versus FEC, in which the Supreme Court struck down the Federal Election Campaign Act's limits on the ability of political party committees to coordinate expenditures with their candidates' campaigns. The court held that the limits violate the free speech clause of the First Amendment. Writing for a 6-3 majority, Justice Kavanaugh held that the limits on party committee coordinated expenditures were not justified by the government's claim that the limits were necessary to prevent circumvention of the base limits on contributions to candidates. Justice Kavanaugh held that the government already has sufficient tools for preventing quid pro quo corruption, such as the base limits on contributions to candidates and party committees, the ban on donor earmarking of donations, and mandatory disclosure laws. The court's ruling this week in NRSC overturns a 2001 precedent known as Colorado II, which had upheld FECA's limits on political party coordinated expenditures. Justice Kavanaugh argued in his NRSC opinion that the court's deregulatory rulings in Citizens United in 2010, McCutcheon in 2014, and Cruz in 2022 had rendered Colorado II inconsistent with the court's modern campaign finance doctrine, which only recognizes quid pro quo corruption as a constitutionally permissible government objective or interest for burdening First Amendment rights. He also emphasized that the Colorado II court based its ruling in part on its concern that political parties would exercise outsized influence in political campaigns and elections. Justice Kavanaugh pointedly noted that the political parties are weaker today than they were in 2001 when Colorado II was decided, and that in Justice Kavanaugh's view, Colorado II was one of the reasons why. Ned and Steve, my first question is this. Is the court right to be concerned about the diminished role of political parties in campaigns and elections since Colorado II was decided in 2001?
I think so. Of course, part of the diminishment is the court's own responsibility in the sense that the diminishment is relative to the growth of super PACs. And the role of super PACs was unleashed essentially by the court's decision in the well-known Citizens United case in 2010. It took a DC Circuit decision that was following up on Citizens United to really give the green light to super PACs, but no doubt the Supreme Court blessed that DC Circuit decision. And so once super PACs dominate the role of political campaigns in the way that they didn't used to, that does atrophy political parties. And that's not a good thing from the perspective of most political scientists, and I think a lot of election law scholars as well. And the reason is political parties aren't, they have their own point of view, but they're not special interests quite in the same way that PACs are. Political parties have to organize themselves for the purposes of government, in terms of the majority party in the legislature has to come up with a programmatic agenda, and the minority party in the legislature wants to be the majority party. So there's a sense of institutional responsibility associated with political parties, which isn't necessarily true with special interest groups that can be one issue only groups and not think about trading off the pros and cons of environmental regulation versus economic security versus, all sorts of things, right? So I think democracy is better served when you have strong political parties. And so you can understand why the court would be concerned about it.
Yeah, I think I am essentially in agreement that political parties are comparatively weak today, and it's not entirely because of the campaign finance system, but that's a part of it. And as Ned said, one part of the way in which political parties are weak today because of the campaign finance system is Citizens United and Speech Now. And because of all of that, this particular decision makes the campaign finance landscape today, the day after the decision, in some ways better than it was the day before the decision. But at bottom, all of this is a result of a jurisprudence that has been particularly narrow in terms of the government interest that the court has been prepared to acknowledge, that it's been limited to quid pro quo corruption, as opposed to a number of other potential interests that at times Congress itself has wanted to try to respond to in the way in which it has developed federal campaign finance regulations, federal campaign finance law. And ultimately, in a really sort of fundamental sense, it goes back to a question of what does the First Amendment itself call for with respect to political speech and political expenditures, and whether there is a distinction to be made. In Buckley versus Vallejo, the court now 50 years ago said essentially no, that spending money on politics is a protected First Amendment activity. There are other robust democracies around the world that have very strong protections of political speech rights that have chosen to make more of a distinction between outright expression of views on the one hand versus the expenditure of money to communicate those views. But we have a jurisprudence that has taken a different trajectory, and it's because of that and the quid pro quo focus that the court decided to give political parties a little more of an opportunity to compete.
And yeah, I agree with Steve in the sense that I'm not particularly a fan of the court's campaign finance jurisprudence, but that's sort of water under the bridge in a way. I mean, we're not going to see a revision of the court's view anytime soon in terms of the major fundamental premises. It would require a substantial changing of the composition of the Supreme Court, given the current 6-3 majority. And so, and again, as Steve said, that this basic prevailing jurisprudence is not just the current Roberts 6-member majority. It goes all the way back 50 years in that Buckley versus Vallejo decision. So as long as the Buckley framework is the dominant framework, and especially after Citizens United, it seems to me that this new decision is a good decision given those premises. If you want to rethink the premises, then I think you could rethink the entirety of the jurisprudence, in which case this case would come out the other way. But in a world in which the premises are fixed, this was the right decision, in my view.
Ned, I think it would be worth exploring a sort of alternative history. What if we were to move beyond quid pro quo corruption as the one recognized interest from the vantage point of the current Supreme Court to justify burdening First Amendment rights? What would a campaign finance system in this alternative world look like? And again, stipulating, of course, as you said, this is not something coming on the horizon. The court has spoken very clearly over the last 16 years that it will not permit any other interest to be the basis on which to build a campaign finance framework. But if you could, if we did have a different court, what would you want to see our campaign finance system look like, both in terms of law and policy?
Steve, do you want to tackle that first?
Well, you've written on this more than I have, but I'll just say, and this is a bit of a roundabout way to respond to your question, Tony. I find myself wondering whether there are enough things that are dysfunctional with our politics today, that we might find ourselves sooner rather than later needing a more dramatic restructuring. And that might include a constitutional amendment or two or more. And of course, if the public itself became sufficiently disgusted with the role that wealth is playing in politics, then a different set of interests could hold sway in terms of what we want to protect constitutionally or not. And I do think we are, increasingly aware of the way in which extreme aggregations of wealth affect the way in which our representatives behave in a way that's counter to the aspirations we have for democracy. Now, that's a roundabout way to come back to your question, Tony, of saying, I do think over the years, Congress itself has on occasion wanted to recognize as some other legitimate government interests, making it possible for groups across the spectrum to be able to express their views with relatively fair loudness, if you will. I mean, the metaphor here that we hear a lot is that the amount of money that is behind a particular view allows that view to be using a larger megaphone, and that people without the resources don't have the large megaphone to share their view. And so Congress has on occasion been interested in leveling the playing field a little bit more. And I'll also say that on many occasions, many members of Congress have talked about corruption in the political process in a broader sense. I mean, they have themselves used that term on occasion to talk about the way extreme wealth influences the political process, calling it a corrupting influence. It's not quid pro quo corruption, but it is, in the view of many, a kind of corruption.
Yeah, and I'll again agree with Steve. I mean, I would be even more forceful maybe to say that I think there's a legitimate political philosophy point of view to say that the value of democratic equality requires some notion of equalizing resources for election purposes. Now, I'll admit that it's difficult to draw the line between that realm that should be governed by a principle of equality versus the realm that should be governed by the principle of freedom, because you have to acknowledge that wealth is going to affect the ability to speak in society more broadly. Hollywood as an institution has more economic clout to convey messages, whether they're aesthetic messages or political messages or sociological messages smuggled into the TV shows and the movies that Hollywood produces. Newspapers are owned, Rupert Murdoch owns newspapers and TV stations and so forth. And if it isn't Rupert Murdoch, it's going to be the Schultzberger family that owns the New York Times or whatever. And so wealth is going to affect the ability to communicate in a free market society. There's no doubt about that. And anybody who's interested in fair campaign finance laws has to acknowledge that. But by the same token, there are some contexts in which the value of equality controls the amount of speech that any one person can say. So sometimes I like to say that the oral arguments that are held at the Supreme Court in campaign finance cases are governed by a rule of equal time for petitioners and respondents, right? Neither side is allowed to buy more time in the oral argument. We don't allow for that. And likewise, in the context of elections, a campaign is not allowed to buy a larger font on the ballot, right? On the printed ballot, both candidates or all candidates have to have the same font size, so they can't, get that proverbial bigger megaphone on the ballot itself. And so the question, I think, that citizens, real citizens, not institutions called Citizens United or whatever, but all of us who care about democracy should ask ourselves is, do we want election-related discourse to be governed by that equality rule like the ballot itself or like oral argument time? Or do we want it to be governed by the freedom rule like speech in general? And the Supreme Court has answered that question by insisting that it's got to be the freedom principle that prevails as opposed to the equality principle in this context. And I don't think that's necessitated by the words of the First Amendment. It's the same First Amendment, whether you're talking about oral argument or the size of the font on the ballot or how much money you can spend on election speech that's different from regular speech. And so I think the Supreme Court took the wrong, and let's again be clear about this. Buckley versus Vallejo is emphatic in saying this equality idea is completely inappropriate, the majority said in Buckley. I don't think that's correct, but that's where we are.
Ned, on that point, one of the things that I think is so striking about the politics of the last 10 years is that not only are we seeing populists become really the dominant force, the most dynamic force in both parties. We're recording this the day after the Supreme Court's NRSC ruling. We're also recording it right after the Tuesday Colorado primaries, where we saw some Democratic Socialist candidates, one in particular, defeat an incumbent liberal Democratic member of Congress. We saw a week ago a similar phenomenon in New York. And of course, since 2015, we've seen MAGA candidates on the right defeat traditional Republicans. And both the Democratic Socialists on the left and MAGA on the right are rightfully identified as examples of how polarized the country is. But what's so striking to me in the context of campaign finance law is that there are some cases where when Alexandria Ocasio-Cortez or some other Democratic Socialist supporting candidate like Bernie Sanders says something about campaign finance, and it sounds a lot like MAGA candidates who criticize our campaign finance laws. And to me, that I wonder if this is going to create pressure on the court over time, where you have polls that show well north of 80% of Americans support campaign finance restrictions, large majorities of Republicans as well as Democrats, and candidates on both the right and the left who identify our deregulated campaign finance system as the source of establishment power that they're challenging. I wonder if over time this will make it increasingly difficult for the Supreme Court, when it worries about its own standing in public life, to chart the course that it's been on now for, as you said, Ned, since in many ways since the 1970s.
Yeah, it's a really good question. I mean, I certainly don't have a crystal ball. Our system is so brittle because it's so difficult to amend the Constitution. The public will for change can be thwarted for a long, long time. Think about the electoral. I know we're talking about campaign finance now, but the Gallup has been polling on does Americans want to get rid of the Electoral College, for decades and decades. And I think I'm accurate in saying that it's never been below 50% in any of their polls. It's sometimes as high as 80% want to get rid of the Electoral College, and yet we don't have the institutional capacity to do it because we have such a difficult amendment process. So in some ways, this is easier to change because you would change it not through a formal constitutional amendment. You'd change it through different justices on the court. But again, I think that's, I don't foresee that, frankly, in my lifetime. Maybe 50 years from now, the court, or 30 years from now, the court will look different than it currently does, and be open to rethinking Buckley. I don't know, Tony and Steve, what do you guys think on this?
Well, I guess even though I see this issue as pretty fundamental to our political system and a significant contributor to its dysfunctionality, I think there are, in some ways, bigger issues that have to play out in the next decade or so, give or take, in terms of what the American citizenry think about our federal government and whether that will produce a shift in the way the court thinks. There are plenty of other big decisions coming out of the court this term and this week that aren't election related, but that are factors in the way in which our public will feel about our government. And that, I think, is going to be more important in terms of figuring out how the court behaves.
I suppose one way to think about this question is, if for some reason a new constitutional convention gets called, because there are some efforts to get a new constitutional question, how would that convention handle the topic of campaign finance? Because I've got to think that topic would be on the agenda in the way that it wasn't explicitly on the agenda, in the convention of 1787. So, obviously it would depend on who the delegates to the convention was and what the mechanism for getting delegates and whether that was gerrymandered or not. But Tony, if you're right that there's going to be pressure from the MAGA right as well as the populist left to, and it's that pressure that calls for the Constitutional Convention, that would be kind of an interesting thing to know about I don't know, Tony, what's your thoughts on this?
And certainly, Ned, I think it's clear that here in midsummer 2026, the Republican Party's in a position where they will probably benefit more from this ruling, because it is true the RNC has the Republican National Committee, who's one of the litigants in another case we're going to talk about today. It has a huge war chest. The Democratic National Committee struggled to keep up with. And I think there is a general sense that Republicans are going to have a financial advantage in November that they have not had in recent cycles, where we've seen the Democrats actually outspend the Republicans in presidential races. So I do think while I think rhetorically, certainly there's a significant part of MAGA that's very critical of campaign finance, the deregulatory bent of campaign finance law, I think the practical realities in the near term certainly are going to encourage Republican politicians to continue to oppose any significant campaign finance restrictions. In fact, it's interesting. There's an emergency application filed this morning or yesterday in the Fourth Circuit. Sherrod Brown actually is one of the plaintiffs who are challenging the FCC's, as I recall, it's the FCC's guidance on the lowest unit charge rule. And just want to forgive the SIs to forgive me for really getting to the weeds, but it's actually a very interesting issue. For over half a century, federal law has required television broadcasters and radio broadcasters to provide heavily discounted rates to candidate campaigns, which is why a donation to a candidate campaign can't be compared one-to-one to a super PAC, because super PACs often get charged 5 to 10 times what candidate campaigns do by broadcasters. And what's interesting is the FCC guidance from a few months ago to broadcasters was that they should provide the same discounted rates to parties engaged in coordinated expenditures with candidates that they provide to candidates. And basically, Democrats are challenging that because it would potentially have the effect of magnifying the Republicans' advantage right now with the party committees. Their war chests will go a whole lot farther if they can buy time on broadcast television at rates that are the same level that are charged to candidate campaigns, whereas super PACs are paying basically what Miller Lite is paying for their ads, as max rates, or car dealerships. So it's a very interesting, it's in the Fourth Circuit right now. And I think briefing has just been scheduled on an emergency basis for next month because it has to be resolved 60 days in advance, obviously, of the general election, because the FCC rule requires the discounted rates to begin within 60 days of the general election. So anyhow, all that is to say, I do think the Republicans see a real advantage in the near term with this ruling that might make them less inclined to support any significant changes.
No, interesting. Yeah. Hey, can I ask you guys a question about the case? I very much respect Justice Kagan on the court. She's super, super smart and thoughtful. I'm curious as to what you think of her dissent. If, in other words, even if she has the view that Steve and I were expressing, that maybe this jurisprudence from the get-go went off on the wrong foot, does she lose some credibility as a justice if she's dissenting without challenging the entire jury? I mean, as I read her dissenting, and I read it fairly quickly, so you tell me if I'm not being fair to it, it's like she wasn't trying to challenge the major premises. She realized that's not a non-starter at the moment, and yet she's trying to defend this congressional restriction within the context of the existing framework. And that just came off to me as not really credible. The right way to attack this case is to attack the entirety of the framework. But within the framework, this, as I said before, I thought this was a good decision. So, I worry that the three liberals on the court in general, and particularly in this case, start to lose some of their, oomph if they're crying wolf all the time in dissent. And this just didn't seem to be worthy of that kind of objection, given what the playing field is today. But I'm curious if the two of you see it differently.
Yeah, that seems to me to be a fair question, Ned. And again, this is also just on very quick look at the opinion so far, but it was almost like, well, we're not compelled to give up Colorado Republican 2 by Citizens United or Cruz. Those don't require us to give it up, and we don't want to give it up. It used to be something that mattered, and we're going to stick to it, kind of a thing, but without the nuance that maybe might have been called for.
But the erosion of the power of the political parties. I'm a big fan of stare decisis in general, but one of the reasons to get rid of a constitutional precedent is if the legs have really been knocked out under it by other doctrinal events, and B, there are real-world pernicious consequences to the opinion, the precedent that weren't realized at the time. And it seems to me that, the doctrine, whether we like it or not, has really superseded. I mean, Colorado 2 was kind of the last gasp of a more pro-regulatory approach within the confines of Buckley. But again, once you have Citizens United, et cetera, et cetera, et cetera, et cetera, on the deregulation front, Colorado 2 kind of sticks out like a sore thumb, and it is having pernicious consequences in the world in which we live. And there's this technical debate in the case about this, whether or not anti-earmarking rules suffice to stop quid pro quo corruption. Earmarking is when you give a contribution to the party and you tell the party this is earmarked for the benefit of a particular candidate. And basically, I thought the majority had a decent point to say, look, we've got anti-earmarking rules. These coordinated expenditures are not earmarked expenditures. And so, when a donor gives this money, they can't be sure that a candidate is going to get it. If they want to be sure, they got to earmark it, but earmarks are governed by different rules. And I didn't see a strong response within the confines of the technical point. I think to your point, Steve, it was just like, we like regulation, but it's like we want to cling to whatever regulation we can cling to, and that didn't seem to me a strong position.
Yeah, I entirely agree, Ned and Steve. And I think in some ways it's particularly striking because no one really has been happy with our campaign finance system since Buckley. It created a hybrid system that was heavily regulated in some areas and not in others. And if we're ever going to fix the system within the confines established by the court, both sides are going to have to be pragmatic and realize that reform for the sake of reform isn't a good thing. And just like deregulation for the sake of deregulation isn't. And it's important, I think, for the dissent to maintain credibility, as you said, to acknowledge that sometimes reform, especially in a hybrid system, leads to negative consequences for the system and for the candidates. And the one other thing I'd add, it's hard for me to see how any candidate is really can be happy with this system where they have to raise unlimited amounts of money in small increments, which mean, and this is a subject for another day, but there's certainly, as you both know, a tremendous amount of political science evidence that Buckley v. Vallejo changed who gets elected to Congress and who moves into leadership positions, because in both parties, your number one claim to a leadership role is your ability to raise money. And that was not true prior to the 1970s at all. It was being a legislatively skilled leader, and money would be raised secretly and in huge amounts over a short period of time. Whereas now candidates are expected to be on that fundraising treadmill all the time. And the leaders have their own joint fundraising committees, and they're in that role because they're so good at raising money. And to me, I don't know how anyone can look at that system and think that that's an ideal way to fund your campaigns.
Yeah. That's a good point.
Great.
Well, perhaps this is a good time to use our remaining minutes to discuss the Supreme Court's second major election law ruling of the week, which is Watson v. Republican National Committee. In Watson, the court held that federal election day statutes do not require ballots cast in federal elections to be received by Election Day. They only have to be cast by Election Day. And thus, federal law does not preempt a Mississippi statute that permits absentee ballots to be counted if they arrive within 5 business days after the election. About 30 states have similar laws as Mississippi's. Writing for a 5-4 majority, Justice Barrett held that the defining element of an election has always been the electorate's choice of candidate, and not the receipt of the ballots or the counting of the ballots by election officials. She acknowledged that election fraud and its appearance are serious issues, but she concluded that they must be addressed through legislation and not through the Supreme Court reinterpreting statutes that are over 150 years old. So, Steve and Ned, my question is this: did the court get it right in Watson?
Yes. For a combination of reasons, I say this ought to have been an easy case. And as Justice Barrett's opinion talks about, as you said, it's long been common to be counting ballots after Election Day. And in fact, all over the country, jurisdiction after jurisdiction will be counting after Election Day in different configurations. Sometimes it's a recount, but the recount is still a count, and it's the official count. And the notion that somehow if the ballot hasn't been available for counting on Election Day means it can't be counted would give rise to problems, not just with respect to mail-in ballots, potentially. If there's a package of ballots or a precinct's worth of ballots that somehow got missed on election night, but is found as a result of the canvass, now it would be thrown out too. So, the notion that what is fundamental is that voters have expressed their opinion in an officially countable ballot by Election Day is what ought to matter. I will also say that had the decision come out the other way, it was going to cause a dramatic degree of consternation and difficult adjustment in jurisdictions all over the country. So anyway, yes, they got it right, to answer your question.
I concur. I'm really quite heartened by this opinion by Justice Barrett. I thought it was well written and well reasoned, and showed that she and the majority were being appropriately judicial. She says, we're not doing policy, we're just doing legal interpretation, and that's what she should be doing, what they should be doing. And to be clear, I think I've said it on previous episodes of our podcast, I do not think it's a good policy to let absentee ballots arrive late. For overseas and military ballots, yes, maybe it's necessary, but I do think, for example, the California primary results, it is a problem that California takes so long. Now, I think that's been demagogued by Trump and some of his allies. All those ballots that eventually get counted are valid ballots, but it would still be better and healthier for our democracy to be able to come up with at least preliminary results. Recounts, yes, sometimes you need a recount, but at least to have a preliminary certification of the outcome much sooner than what California does. But that's policy. As a matter of just statutory law, I think it's been clear for decades what Steve describes, that it is permissible for states to allow voters to vote an absentee ballot that arrives after Election Day, as long as it was postmarked and thus proved to be voted on or before Election Day. That's been standard operating procedure that everybody thought was the law, and it would have been very revisionist in an inappropriate way for judicial interpretation to change that law. That's, as Steve said, that's Congress's job. So, hallelujah for, appropriate judicial behavior. And for that reason, I'm especially worried that it was only a 5-4 decision. It worries me that there were other justices on the court who were really willing to manipulate the process, for result-oriented jurisprudence, where an honest assessment of the law was what the majority did. One final little point, but one of the pieces of evidence that Justice Barrett relied upon for statutory meaning was the relatively new law called the Electoral Count Reform Act that was adopted in 2022 after the horrific debacle of January 6th, after the 2020 presidential election, and the abuse of the predecessor statute by Trump and his allies in Congress. And a bipartisan effort led by Susan Collins and Joe Manchin on the Senate side, came up with new procedures in general. But one of the elements of the new procedures was an amended definition of Election Day. And it was amended in a way that was based on the predecessor understanding of what was permissible by way of receipt of absentee ballots. And so I think Justice Barrett got it absolutely correct to say, look, this was a signal that Congress understood what the practice was and was legislating based on well-settled practice on, prior understanding of the meaning of Election Day. So kudos to her because that was not necessarily a detail that non-experts in the field of election law would have picked up, I think, but she picked it up, and I thought that was a good thing.
And I'll say, this seems to be a policy fight that's not over, in the sense that President Trump is pressing even harder to get Congress to pass legislation that he'd like to see do something about this issue. We've continued to predict over and over that that's not going to happen, but he keeps upping the pressure. It won't happen unless either the reconciliation rule is construed by the Senate parliamentarian to let the Senate do something as a reconciliation measure with just 50 plus one votes, or if the Senate scraps its filibuster rule for this. On both of those points, it has seemed unlikely that the Senate would do anything this summer. But if they did, that would also be a really disruptive thing to the established, understood practices. And it would be just immeasurably better for Congress if it were to decide it wanted to get involved here to, in some way, defer the effective date, to give election officials and the public, but especially the election officials, time to adapt and change the processes by which the elections are conducted.
Yeah, 100%. I mean, my policy point is not for this year. It's too late. It's a policy matter for this year. In my view, that would be a policy change for future elections. But you're right, Steve, that Trump is putting incredible pressure on the Senate. If you don't mind, since Steve is such an expert on Senate procedure, having worked in the Senate Legal Counsel's office, if the parliamentarian ruled to protect the reconciliation process in the way that you're describing and said it's off limits for this, is it correct that that there could be a vote in the Senate to overrule the parliamentarian's determination of that matter? And would that be the equivalent of getting rid of the filibuster, or that would just be a different exercise of the so-called nuclear option within the Senate to have the majority force its will over the rules? I mean,
in brief, you're right that the Senate itself is a majoritarian body, and it can do anything it wants by a majority, including jettison the filibuster rule. But they have a long history of respecting minority rights in certain respects, and that's the filibuster rule. And so, that's the filibuster rule is an example of that. And senators on both sides have said we're going to protect the filibuster rule. And with respect to reconciliation, it's analogous. I would say that there's a long practice now dating back to the Budget Reconciliation Act of the 70s of respecting the reconciliation process and respecting the parliamentarian's judgment about that. But the parliamentarian's judgment could be overruled by a majority. But that would be just a dramatic reshaping of the norms by which the Senate has operated.
Thanks, that's helpful.
And it really is amazing to see how difficult it is for the House to get a majority on so many different matters. And you even wonder if the Democrats right now, I think most forecasts project the Democrats will likely take the House back. But with this new socialist element, the DSA members of the House being elected, it's possible the Democrats could actually struggle to elect a House Speaker, even if they have a majority of 223, 224 come January. So we're certainly in an interesting era where just getting to a majority is difficult. Winning the election's not enough to actually have a functioning majority.
So I know we're getting close to our time, but can I ask for your thoughts about one of the non-election law cases, but what it might mean with respect to federal and presidential involvement in elections? We're talking about the SAVE Act and President Trump's pressure on Congress to pass the SAVE Act. And this president seems willing to do absolutely anything he can to try to structure elections the way he wants. He now has the green light because of the Supreme Court's decision in the Slaughter case to run all the federal agencies, arguably, except for the Federal Reserve, and to tell all those previously independent federal agencies what to do, including potentially the Federal Election Commission. Now, the Federal Election Commission is pretty weak at the moment. They don't have a quorum, so they can't actually do much. But I find myself feeling like the Slaughter decision means something different potentially with respect to federal elections than it might with respect to federal trade, at least in light of what this president has been doing. I'm just curious what you might think about the Federal Election Commission is no longer so independent.
I haven't thought about this since Slaughter was decided, but in anticipating what Slaughter would do, which it did, my thought had been, and this applies not just to the FEC, Federal Election Commission, but also the EAC, the Election Assistance Commission. I thought that the constraints on those agencies in terms of stopping inappropriate presidential interference would have to come from interpreting, the governing statutes, as opposed to saying that, the president didn't have removal power, for example, which is the, specific issue in Slaughter. So I think going forward, I mean, obviously Congress created those agencies on the assumption that the Slaughter was not the proper way to interpret the Constitution. There is language in the Slaughter majority about severability, and so because I think in response to Justice Sotomayor's dissent, Justice Roberts says, if the claim is that Congress would not have created this agency on the understanding that the president had absolute removal authority, Roberts, for the majority, says that's a severability issue that was not raised in Slaughter itself. So it is possible that future litigation could basically say the EAC is entirely inoperable as an institution, and the federal laws that guide the EAC are inoperable because they were all passed on the assumption that the agency wouldn't operate the way Slaughter requires an agency to operate. The other really interesting thing in Slaughter that I saw, again, I want your views on this, is Robert says, not every entity of the federal government has to be created as an executive branch agency. He contemplates that Congress could create subsidiary institutions to aid in congressional legislative functions, and then the Federal Reserve is this entirely different thing. But he takes it as a given that the FTC is exercising what must be considered executive authority under the Constitution. So I wonder to what extent some of the functions that EAC or might do could be considered, you can't use the term quasi-legislative anymore, but sufficiently legislative that they belong in the Article 1 branch instead of the Article 2 branch. I don't know. I haven't thought that through.
Yeah, that could give rise itself to some interesting litigation too.
Historically, if you look at the history of American elections, the canvassing votes was considered a legislative function, that the legislature, not just for legislative offices. I mean, if you look at gubernatorial elections in the 19th century, most of the canvassing that is done by legislative committees, because the legislature thought it was so important to have the legislature control the outcome of elections. We have the long-standing history of Article 1, Section 5 of each House of Congress being the judge of its own elections. That comes from English history, and there, as Steve has written about state law analogs to that, but it goes beyond legislative elections. And so I really do think you could make an argument that to the extent that there are congressional statutes that govern the casting and counting of votes, they're different from Federal Trade Commission or environmental protection or so forth. But I'm not confident that argument would prevail, but I think it's worth thinking about down the road.
Thanks.
And it is interesting to contemplate a world in which Congress as an institution, not as a partisan institution, but as a separate branch of government, would reassert its prerogatives under the Constitution, since we're living in this era of what Arthur Schlesinger called the imperial presidency, an era that just seems to build with the passage of time. But at some point, you would think Congress, even when they have a president of the same party at the other end of Pennsylvania Avenue, that Congress will become more assertive, claiming its powers under the Constitution, which it really seems like we have not seen for many years. Well, on that note, that criticism of the imperial presidency and call for Congress to assert its powers in Article 1, I'd just like to thank Steve and Ned for another great discussion. Please don't forget to like and subscribe to Law and Democracy, and look for our next episode on YouTube and Apple Podcasts.